Hey folks, Dale Davidson here, Dear VA Guy. I'm going to mix things up a little bit today. I'm going to mix some estate planning up with some VA questions that I have gotten. I'm getting a lot of mail today, or this past week. So it says, Dear VA Guy, the VA has denied my disability, but they haven't given me any reason. Can you help? Look, they should have given you a notice of decision, okay? If they haven't, contact them and let them send that to you, because without more, we don't know exactly why they denied you. Maybe it was a service connection. Maybe it was you didn't have enough medical information. Whatever that is, you just need to get that letter and then contact us, and we can help you from there. Here's our second letter. Dear VA Guy, my father has been or was in the U.S. Coast Guard. It was during the Vietnam era. He doesn't really want to apply, but I think he needs to for exposure to Agent Orange. He was on a boat in the coastal areas of Vietnam, but never really, he set foot on land, but only, to get supplies. He mainly stayed on the ship. Would he qualify? Well, yes, he would. He would qualify because, assuming he had the requisite eligibility dates on his DD-214, and you say he was in during the Vietnam era, and that he had needs assistance with activity of daily living, but you say you mentioned prostate cancer here. That is a presumptive condition for people who were in Vietnam. Now, because he was in the Coast Guard doesn't mean that he's not otherwise eligible. He probably wasn't in the blue water like the big Navy ships, but regardless of whether it's blue water or brown water, he still could qualify based upon, we've got the nexus letter here. We need to make sure that he has the medical evidence to support the prostate claim. And again, remember the magic words. It's more likely than not that his service in Vietnam during this period of time caused him to be exposed to Agent Orange, which then caused him to get prostate cancer. So, yes, given all these the limited facts that I have now, yes, he should still qualify. Okay, here's Dear Nursing Home Guy. So, my husband went into a nursing home, and I have given the nursing home all the information that I had, all the financial information, and they say that he doesn't qualify because his income is above a certain limit. Before I applied, though, I set up a qualifying income trust, and the agent for the department told me to put in $60, which I did, and here are the deposit slips. Now they've come back and said I didn't deposit enough money into that account, so therefore that qualifying income trust was not valid. What can I do? I can't afford the $10,000 nursing home bill cost, and please help. So this is years ago. What would happen is somebody would set up a qualifying income trust because their income was above a certain amount, and that amount's usually about $2,200. Okay, so let's assume in this instance that it was $2,500. Generally, the DFACS wants you to put all your money into the QIT, all your spouse's money, then that would be paid to the nursing home. But in this case, we've got two different things going on here. We've got your spousal allowance. Because your income is much lower than his, you're able to reach over his wallet and take money out and put it in your purse, okay? So that's one issue. The second issue is the rule says you must fund the QIT initially with a reasonable amount. Well, what is a reasonable amount? The only advice that I've ever heard was a reasonable amount was $50. Well, here we've got $60, but I'm hearing nowadays that they're wanting a larger amount to be put in there. But there's no guidance there as to what a reasonable amount is. So in this case, and I think your only alternative is to file a request for a fair hearing and get before a judge to say, hey, look, this defects worker told me $60. That's what I did. Now they turn around and said it should have been $200. Well, if I'd have known $200 back then, I would have done that and we'd have been okay. But here we are. We've just got to get before the judge, administrative law judge, and make the case that, look, you were instructed by this defects worker that the reasonable amount was 60. Because you really don't know what that is. You don't know what that figure is until somebody tells you what it is. Because they do their calculation, but they don't do their calculation until they get all that information. Supposedly they had done all that calculation, or had all the information and done the calculation and gave you that $60 figure. Well, that caseworker is gone for whatever reason. Now we've got a new caseworker, redid all the paperwork, and says, no, the reasonable amount is $200. Should you be penalized based upon bad information from the state? No, but we've got to make that argument before administrative law judge in order to get you straightened out. So, all right, one more quick letter here. Dear nursing home guy, my mother's in a nursing home. My sister was very abusive towards my mother, and I have my mom's power of attorney, and the nursing home has told me that when my sister comes to visit, that she's very abusive to my mother. What can I do to protect my mother? Should I exercise my power of attorney and ban my sister from there, or what should I do? Number one, in my opinion, don't exercise your power of attorney to ban your sister. Okay? That's just going to create bad blood. If your sister is banned, it's going to be because the nursing home banned her. What I would do if I were you, I would talk to the nursing home administrators and the nurses and say, look, my sister's coming in here. She's upsetting my mother. Y'all have witnessed it. So I need y'all's assistance in helping me stop it. Now, it's better off if they ban your sister or have some kind of supervised visitation or whatever you can work out versus you stepping into that. That's a pit you don't want to go into. But if you can't get any satisfaction that way and your mom is still being abused, verbally abused by your sister, then by all means, use your power of attorney to ban her from seeing your mom. That's going to create a whole lot of problems between you and your sister. It might wind up in court, just to let you know that, but your duty is to protect your mom, not your sister. And if your sister is a detriment, then that needs to stop. But the first avenue of defense is get the nursing home involved and see if they will pick up the slack and talk to your sister or ban her or do something in order to protect your mother from her abuse. Because look, they're on the hook too. The nursing home is supposed to be a protected environment so that your mom is safe and secure. And if somebody's abusing a patient, they need to step in and do something also. Hey folks, thanks for checking in today at Davidson Law Offices. Hey, check out this video on nursing home and some asset protection. It'll give you a little bit more information and explain the qualifying income trust a little bit better. And until next time, you have a blessed day.